First of all, welcome to everyone. We're very appreciative of all of you who took the time to join our course today. We hope it'll be interesting. We think it will be. We noticed that there aren't a lot of turnover courses out there, so we thought it would be a really good idea to put this together. Without further ado, I would like to introduce my panelists. We have Will Delgado from the Castle Group. Will is the president of the Castle Group, and he brings over 30 years of experience to his position. The interesting thing that Will can share with us during this presentation is that he's been on both sides of the turnover situation. He's done turnovers on the developer end while he worked with the developer, and he's done turnover on the association end on the condominium unit owner side as well. My law partner, Perry Adair, joins us. Perry is a board certified attorney in construction law. He practices in Miami-Dade County primarily with construction disputes and telecommunications issues. Perry is one of our firm's 558 litigation specialists and has tried numerous construction defect cases. So his input is going to be really, really helpful when we talk about developer claims. And I am Rosa Della Camera, a firm shareholder with Becker. I work out of the Miami office, and I am board certified in condominium and planned development law, or colloquially known as condo law. So what we thought we would do, I talked to Perry and Will before this presentation. We thought what we would try to do today is to help the attendees issue spot, to help you determine where there are situations where you might get in trouble, how to avoid getting in trouble, and to give you sort of a general global idea of what the turnover process consists of, when it happens, how it happens, and what are the repercussions after it happens. So as Laura said, on Monday, you're going to be getting a link to this class. And together with that, I'm going to be sending you what I like to send to my clients, which is a turnover checklist. It's a simple document, but I want to share it with you because it helps me help my clients keep a really good list of what documents need to be turned over. So I'm going to go ahead and include that in Monday's mail out. So specifically, we're talking about turnover. What is turnover, and what is the difference between turnover and transition? Those phrases are both used. It's a condo turnover, it's a condo transition. Guess what? It's the same exact thing. The words are used interchangeably. The statute talks about both, it uses both terms, but it's the same exact thing. There are two primary things that happen at turnover. The first one is that the unit owners get to take over control of the association. How? By holding an election where they elect a majority of the board of directors. And the second thing is that the developer is obligated at that meeting to turn over physically all of the association's property, books, records, official records, contracts, all that stuff. Really, really important, because that is what's going to form the basis, obviously, of the condominium's operations. Also, all of this has to be done at the developer's expense. So there is a very long laundry list, which my checklist that I'm sending to you will contain, a very long laundry list of documents that need to be turned over at that transition meeting. And in condominium settings, the developer has up to 90 days after that meeting to turn over some of the documents, including the audit. The audit really is the one that's given the most leeway, just because it takes longer to prepare. Also at that meeting, when we talk about turnover of property, one of the most important things that gets turned over is the association money. The bank accounts need to be turned over, and all the money. The developer at that point forward is no longer in control of the association funds and finances, which puts the new board members in a really, really important but good position where you can finally control your destiny. The other thing I was going to mention is what triggers turnover. What statutory events, what events are statutorily mandated, I should say, to trigger turnover? Well, I direct you in condominium world to chapter 718.301. 718.301 tells you that the developer is forced to turn over control, like it or not, 3 years after 50% of the units are sold, Or usually the other trigger that is more widely known and used is 3 months after 90% of the units are sold. There are a couple of other triggers in the statute, but in my experience in doing this over 30 years, most of the turnovers I've handled are triggered by the developer selling 90% of the units. That triggers the 3-month turnover requirement. Also in homeowner associations, that same 90% trigger applies. So in a homeowners association, in a chapter 720 association, you have many less triggers than are contained in the condo law side. But the main one there is also 3 months after 90% are sold. And in the homeowners context, I would direct you to chapter 720.307. 720.307 is the sister statute, if you will, to the condominium turnover statute. A lot of times, and I want to ask Will to jump in here. You know, Will, what I get a lot from my clients, and you as the management company probably get it as well, is owners are afraid to take over control because the property has not been completed to their satisfaction or hasn't maybe been completed at all. So from a procedural, or, you know, what is your experience with this? And do you counsel owners to turn over or to try to delay the turnover?
Yeah, so that is a common fear, Rosa. You know, I can tell you just quickly, when I was a developer, you know, in Florida, we tend to have a heated market in real estate. And one time I was turning over a building and it had already been sold out. So technically it was available to turn over immediately. And you can imagine the fear of the homeowners and what happens now. We're not prepared for this. So what do we do here on the management side? Yes, we do in fact counsel our homeowners who are about to become board members. We advise them that they should form their own ad hoc committee so that you can start the communication flow between the developer and the potential board, as well as keeping other residents within, whether it's the building or the community, if it's an HOA, informed of how things are progressing.
I think that's a really important point, because I too counsel my clients not to fear turnover, to welcome turnover, to push for turnover as much as you can, because again, from that moment on, you control your destiny. And most importantly, you have control of the association finances. So sometimes in condominium turnovers, one question I get is that the developer has collected, I beg your pardon, that the developer has carved exceptions for payment of assessments. They've done basically a guarantee period. So one of the things I wanted to mention, and we're not going to go into great detail about this right now, but as I said, we're issue spotting. Keep in mind, check your documents to see whether there is a developer guarantee. What does that mean? That means that the developer will say to the association, I'm not paying assessments for a specific preordained period of time. There's a beginning and an end date to the days that the developer does not pay assessments. But conversely, if they opt to do that, then they have to fund the year-end deficit. So to use a very simple mathematical example, if you have a $100,000 budget at the end, and at the end of the year, you've gone over by $20,000 and the developer didn't pay 1 cent towards assessments, that $20,000 of that deficit has to come out of the developer's pocket. How long is that budget guarantee for? It depends on your governing documents. Can the developer extend the guarantee? Usually the governing documents will allow for it. The statute does as well, but you can't just say there's going to be an endless developer guarantee where I don't pay assessments and I guarantee the budget. There have to be a beginning and an end date. But I mention this because it is important at turnover that the newly elected board makes sure if there was a developer guarantee, and for how long did that guarantee exist. There's also one other issue spotting moment that I want to mention here, which is the capital contributions. Oftentimes developers will force owners to pay money towards a capital contribution, and the monies are still there at turnover. I mean, those monies, unless the governing documents specify otherwise, at turnover, they're the association's monies. They're for the association to use as needed, and obviously as needed means for proper, proper expenses and proper purposes. So that kind of, in a very quick way, summarizes when turnover occurs, what the triggers are. But I really, really want, and Perry and Will do too, when we spoke earlier, wanted to focus this conversation on preparation before, during, and after turnover, and statute of limitations issues, and when can you file claims and things of that nature. So I'm going to ask Will, from a management perspective, walk us through, what do you do when you have turnover on the horizon and you know it's coming up because the 90% threshold has been hit of units sold? What do you do? What next?
Right. So Rosa, very much like your firm, internally, we have a checklist as well. So for these communities that are about to turn over. And in ours, if the turnover, we look at where the community is with its sales, with the developer and so on. And our checklist actually starts a year out, where we'll be keeping an eye on certain things. And then as we get closer, 6 months out, 90 days out, 1 month out, there are a series of different actions that we'll be advising the community as to what's about to happen here. And then we start really partnering up with the association attorney like yourself to ensure that we're going to have a smooth transition. But
Will, sorry to interrupt. Do you usually work with a turnover committee? Who are those people, and how is that committee formed?
Yeah, so yes, we do. That committee is formed. Quite frankly, we'll start soliciting for volunteers from the community, bring them on board, explain to them what they're going to be doing. We walk them through our process. We start telling them the things that they can expect from the developer. On the agenda that we had looked at jointly before the call here, Rosa, we talked about what are these items that we should be getting from the developer. So we'll start telling them these are the things to look for, helping them draft all the documents on their end. And then we start preparing as we would for any community when there's going to be a new board. So we're going to identify those folks who are putting their name in the hat to become part of the board. We start talking to them about organizational meetings and elections and so on. But this all to make it easier for them in the transition.
Absolutely. Sometimes too, when turnover happens, there's still a developer representative on the board, which oftentimes makes it a little awkward. And I'm going to talk to Perry in just a few minutes about how to avoid conflicts of interest if you've got a developer employee or representative or agent on your board when you're talking about claims. And I know that, that Perry's dealt with that, as have both of us. But before I get to that, I just wanted to spot that issue, that not always are you going to elect the full board of unit owners. Sometimes there's like a straggling member of the developer still on the board when the developer still owns enough units to allow for that. So you may have, it's never going to be a majority of the board. You may have a 3-member board and 1 developer appointee and 2 board members elected by the unit owners. So that scenario can happen, but there are ways to build, walls to protect the confidentiality of the information that you want to talk to your unit owner elected board members about. So, Will, you talked a little bit about the pre-meeting, let's say prep. So let's talk a minute about the turnover meeting itself. And, I sometimes tell my clients that just because it's time to turn over doesn't mean it's going to happen right away. Sometimes it can take up to 7 months, because remember, the trigger happens, you have 3 months, right, after the 90%. You don't call the meeting the next day. The developer has, after the 90% trigger is hit, they have up to 3 months. Then you have to call the meeting 75 days after that. And then you have to give a 60-day notice of election. Look at all the months we're talking about. So the turnover meeting will require a 60-day first notice and a 14-day second notice in the condo setting. In the HOA setting, of course, those timelines don't apply. Why? Because you're holding an election and because that's what the statute requires. So Will, in terms of calling the actual turnover meeting, do you typically see that the unit owners have, and especially if you have an owners committee, that they've almost come up with a slate of owners that they want? Or is it kind of like a free-for-all? What is the typical way that you see turnover meetings happening?
I will tell you that there are two things that really affect that. The first being just how seasonal a building may be, Rosa, and I've been involved with associations on the west coast of Florida as well as the east coast, and the west coast tends to be more seasonal. If that's the case, sometimes you have difficulty trying to get people to join committees, et cetera, because this is not their primary residence. So if that's the case, we on our side have to do a lot more solicitation of the community to say, look, folks, these meetings are being set and we're going to need representation from the homeowners. Secondly, it also depends on just how smooth the relationship has been with the developer. And I can tell you, as a former developer in the company I worked for, we knew that the end state was always going to come down to this turnover and then subsequently a 558 settlement, which of course we tried to maintain the best relationship. So if it's gone smoothly and the developer and the residents who have been involved up until this point have had a cordial relationship, typically it's much easier to get everybody involved and to move things along as, in a mutually agreeable time frame. If it's been contentious from the beginning because there are physical issues that have presented themselves in the building and whether it's the developer or the developer's general contractor have been slow to respond to those items, it's a different story, right? You're going to have people there, beginning to form the opinion that the developer is the enemy, and we need to get everything out of them that we possibly can. And so therefore, that starts guiding a lot of their opinions on how they're going to behave in any interaction with the developer going forward.
And the turnover meeting, because it's an election, you have to go through the same, rigmarole that you would for any annual meeting. I have a turnover meeting that I'm doing for one of my clients in a couple of weeks. And what we did there is we combined it with the annual meeting so that there wouldn't be two election meetings back to back, which would make no sense. So we called it as the annual meeting / turnover meeting. And what we did there is we sent out the first notice 60 days before, solicited candidates to run for the board. And then the second notice, of course, went out with the candidate names, with the ballot 14 days before, sorry. So that election will happen in a couple of weeks. But, and of course, it has to be by secret ballot in a condo setting.
Absolutely.
Because any election has to be it a turnover meeting or a regular annual meeting election. And in a homeowners association, it's similar, except for that you don't need the two notices. You only have the one notice requirement, and elections are done at the meeting and nominations are taken from the floor. You don't have that whole pre-meeting registration candidate requirement that you would in a condo. But one of the really, really big things that happens at turnover is that it starts the new board's obligations of so many things that have to happen during that first year. And I'm going to jump around a little because I have a list of things I want to talk about, but because this is one of the most important things that happens, I want to ask Perry. Perry, one of the things that have to be turned over in that whole laundry list of things that I talked about is a report, an architect's report or an engineer's report discussing the community and the structural deficiencies and what have you. As association counsel, your client has now received that report. What is your advice to the association? Do they accept what's in that report? What would you tell your client to do?
So first, thanks everyone for attending. This is a very important point you're discussing because the temptation is that the developer has provided us with a statutorily required report, and it's given by an engineer or an architect, and so it must be reliable. They must be telling us the full story, and let's just accept that. I recommend against having that mindset. From my perspective, again, the day-to-day or transactional turnover issues are not really my expertise. My part of this is in turnover. What can you do to best set yourself up if you need to bring a claim for construction defects? So we have seen associations say, well, I have this report, I don't need anything else. I advise against that. Now, I'm not going to say that the developer, because you don't want to paint too broad of a brush, the developer might get an excellent engineering firm, architectural firm that does an in-depth report and reports everything that is a problem with the building, or maybe they don't. My suggestion to you was your mindset be maybe they didn't, and I think you need to get your own engineer to do an inspection, notwithstanding what is in the report that's delivered under the statute, which, by the way, I should tell you is not always delivered and sometimes has to be chased after. In our world, meaning the folks that pursue the construction defects, and we'll get to this a little bit more when we get to that section of the presentation, but what we would like people to focus on, just like you focus on the finances and do we have all the money in the account that should be there or not, or have the funds been, what we want is, we want to know the as-built drawings we want to see, we want to know who was involved in the construction, because we want to know who's responsible if we find problems and have to go after folks. And the kind of information that we want you to focus on is a little bit different than turnover in the transactional sense, the money and those sort of things. So that's to answer your specific question, Rosa. I would look at it with askance, I would say, the report you get from the developer, and it's not that you ignore it, but that you should plan on doing your own and should do your own.
So Perry, one of the things that the developer, you just touched on this, has to turn over at turnover are the building plans and the as-builts. And I can't tell you how many times that doesn't happen. They don't turn over these plans. And I don't know why. Sometimes it's really difficult to get your hands on the as-builts. Are those as-builts always filed in the county where the property is located, or those don't have to be filed? Explain that, because it's so critically important for the engineer to review those, and sometimes it's really difficult to chase them down.
So let me tell you a little bit about as-builts. So just for when a developer is going to build, his general contractor will go in with the architect's design or construction drawings, put them in for permit, and let's suppose they get permitted just as they're submitted. Almost never happens. Changes are almost required. But anyway, let's say they get permitted and the building starts. And then during the course of construction, things happen in the field that sometimes they're because people didn't do their job properly, or sometimes, no matter how much careful you are, you run into a conflict in the field. And so when we say as-builts, is that if there's a conflict in the field and this wall needs to be moved, this door needs to be moved, or something bigger than that, they will mark up a set of drawings in the field. And depending upon the magnitude of the change may need to be submitted to the building department for approval. But at the conclusion of the job, what is supposed to happen is all of these changes, all of these as-built, meaning the original drawings called for it to be done this way, actually in the field had to do it this way. They should be all gathered together to an as-built set of drawings. And I say drawings, I mean also the as-built set of specifications. So there'd be a project specification, more called a project manual more often now, that lays out the details of certain components or certain aspects of the building, right? Because the building drawings, you can't put every detail on because it's just too cumbersome and it just can't do it. You only put so much information on a page. But those details are filled in by the specifications. The same thing I told you about the drawings happens with the specs. So maybe product X was specified and they made a change and they said, okay, we'll let you use product Y instead. Or we'll use this method of construction and we'll change the specs to allow it to be done this way. There should be an as-built set of those. The changes to the drawings that require the permitting authority to comment on because they're of such magnitude, and that does happen, then they'll be on record at the building or the permitting jurisdiction's office. They'll have that set because literally what will happen is that the contractor or subcontractor will come in with, usually the contractor, but could be the subcontractor, comes in with a new sheet that takes the place of the original sheet of the drawings. The sheet that the permitting official has, the original is marked void, the new one is slipped in, and now they have it. And I mean, it all gets electronically scanned and captured at some point. But the changes in the field that aren't of a magnitude that require the the building department's approval, or maybe somebody thought they didn't, they did. They weren't not going to have those. So there should be a set, though, that typically the architect assembles, that there's a set of as-built drawings that the developer will have. Those are critical. You have to get your hands on those. And the same thing with the as-built specification. So you know, and let me just caveat it again. Sometimes an as-built drawing marked up, that's not exactly what happened in the field. It depends upon a lot of things, in particular how careful people are. If you don't get those things at turnover, you're really a little bit starting behind the 8 ball if you have a construction defect claim that you want to pursue. Same thing with the list of contractors, subcontractors, suppliers, and manufacturers. You're supposed to get that too. If you don't have that, you're starting behind the 8 ball when you have to. I say behind the 8 ball, but there's so much time can be saved if we have those things on the front end. And it's easy to see why they get overlooked. I can tell you that in a building of any magnitude, and it's not every building, if the developer didn't turn those things over, whether I thought I was going to have a problem or not, I'd send them a hand letter and I'd put the matter in suit if they didn't turn them over. Right?
So if you don't get that, if you don't get delivery of all those important documents, especially the as-built plans, you could sue the developer and you would win your attorney's fees because they have a statutory duty to turn them over.
Yeah, yes. I mean, it is something that's not often done, but I can tell you, having handled cases where I come in where that information has not been obtained, it just makes things much more difficult. And when you have a right to it, they ought to turn it over, and there really shouldn't be any fight about it. I mean, it's a little bit time-consuming and maybe cumbersome to gather all the as-built drawings together. But typically, the contractor has an obligation to assemble that set and give it to the developer before they get final payment. So it's not like this stuff doesn't exist. But it doesn't receive it depends on which part of the turnover you're handling, right? So from our perspective, the construction defect litigators, this part doesn't get enough attention when we're doing our turnover work.
So Perry, one part that I know does get a lot of attention, you talked about it and so did I earlier, which is the developer at his or her cost or its cost is required to turn over this architectural or engineering report. Okay, we, to put it bluntly, don't believe a word on the paper it's written on. So we meaning the association, are going to go out and hire at our cost and on our dime, our own professional to not only review that report, but also to do a physical property inspection to issue their own report. So how does that work? In other words, if the association just went through, they would say to Will or to me, we don't believe this report. We want our own. Who do we turn to? I know that we don't recommend any engineers, and I don't suggest that we are going to give out names and things like that, which we wouldn't do. But what do you look for in that engineer's report? What do you need to see as the construction attorney?
So what we are looking for is expertise in those areas of construction that we find are most often the problems that we pursue. I mean, it seems like we're pursuing stucco defects all the time. It seems like that we've had very serious problems that we've pursued that had to deal with the chiller systems in big high-rise buildings that run the air conditioning. And so what you're looking for is a firm that has expertise, hopefully across all those areas. Some firms do, some firms don't. There's nothing wrong with hiring separate engineers to look at different components. I don't recommend it because you don't get a comprehensive view because systems interact with each other. So what we look for firms that have engineers in those various areas of expertise, engineers that are, how to say it, there's a big difference between a forensic engineer and an engineer who's doing design work on the front end. Because the forensic engineer, his focus is what should have been done, what was done, and what telltale signs do I see that may not have happened correctly. The design engineer, not picking on the design engineers, the design engineer's job is to put together whatever engineering component he's worked on so they can be in the construction drawings, can be built in accordance with it. But the forensic engineer is looking at it a different way, right? So we look for engineers that have forensic experience. The other thing we think about, and let me just give you the punchline, is when I advise associations about this aspect of their life, what I think about is what can ultimately happen in the courtroom if we get in a full, not to say most cases settle by far, right? So, but if I had to get in a fight about it and I had to have a judge or a jury decide my case, where do I want to be? Who do I want in that witness chair telling my side of the story? When you look at it that way, it becomes very clear what you need. You need a broad-based level of knowledge in the engineering firm. You need someone who focuses on the forensics. And the forensics, by the way, are not just what's wrong, but what is a reliable and efficient way to fix it.
Okay, hold that thought right there, if you don't
Okay.
mind. Hold that
No.
thought, because I need to pick your brain a lot more on that issue, but I don't want to get ahead of ourselves. So hold the thought about the repairs, because that's really important and I don't want to overlook it. But before we get into the repair aspect, I want to go back and ask Will something. Okay, so we're at the turnover meeting. The new board has just taken over. And in that laundry list of items that needed to be turned over is an audit. And by the way, that laundry list I keep referring to, remember, we are sending it to you on Monday with the link to this program. So you're all going to get the list. Don't worry about writing down notes necessarily, because you're all getting the list. Anyways, Will, one of the things we get is the audit, or we're supposed to be getting it at turnover or within 90 days. So we're getting an audit prepared by the developer's accountant. How accurate is that? And do we necessarily believe that? Not unlike the engineer's report. What do we do when we get that audit?
Yeah, Rosa, you had mentioned before cautioning, like the same thing with this engineer's report is the same thing with this audit in our mind. It's kind of a scenario where the fox is guarding the hen house, right? So you're not just going to take it for granted. The association will have their own CPA firm, which will take a look at that to see if the numbers match up. Because again, just like on the engineering side, well, clearly that's what you found, but you were literally hired by the person who may be my opposition going forward here. So we want an independent look at it to say whether or not, and in this particular case, when you're talking about an audit, does it follow gap? Are there anything or any items that within that we believe should have been moved over to the developer side versus what this audit showing? And we'll look for those discrepancies. But again, an independent audit is what our recommendation would be to verify what those numbers are telling us. And
Okay.
Rosa, one other item. Perry was talking before about the plan. So I want to make just two comments on that, both first from the developer side and for our audience and anyone who is potentially coming up to this turnover meeting here soon. So when we did it, we prepared everything as a developer for turnover, but these plans, and I'm going to speak from the condo side of the world because that's what I used to do as a developer, but this set of plans you're going to receive as this new board is literally going to be somewhere between a foot to 18 inches thick. And I don't think many folks recognize just how extensive this will be. And we used to go through an inventory with them by the plan sets. So the architect, the MEP, the structural, et cetera. It's an extensive package that you're going to receive. Perry also mentioned the spec book. Well, in the company I worked for, when we turned over, the spec books were usually 3 4-inch size binders that covered literally everything that went into building that building. So now let me talk to you from the management company side. Perry mentioned that that's what you're going to run through your engineer that you hire as an association who's going to protect your interests. Is going to look at those plans and say, this is what it should have been built like. Let's go see what we find. And frequently on engineering reports, you'll see that something's not built according to the plans or something's not in code compliance. And a lot of that reference point is through those plans. Now, long-term as your management company, I would tell you, you need to have a plan for where are these plans going to be stored and how. All too often, Rosa, you started off before talking about, can you readily get those plans from the city? Short answer for my experience has been, heck no, it's awful. So when you get a good set of plans, have a good place to store them so that they don't get destroyed, because let's assume you've gone through a smooth turnover, you're a few years down the road now, and something comes up in your building and perhaps it's routine long-term maintenance. And someone needs to be able to reference the plans and nobody can find them. And that scenario comes up all too often. So take care of your plans. They are the best resource for when you need to do some other form of repair down the road, that you don't have to do a lot of destructive work because someone can pull the appropriate plan set and know where to go to find something, whether it's a pipe underground, it's some form of electrical conduit that may be hidden behind walls and so on, but it will save you a lot of agony in the future as well.
I thank you, Will. That's 100% correct. I agree with absolutely everything you said. So a couple of the takeaways from the last few minutes of the conversation are, once the new board takes over, they need to hire, the first thing is hire the competent manager and the competent attorney. But immediately after that, you really, really need to hire an engineer. All kidding aside, you need to hire a very competent engineer to do a, top to bottom assessment of the property, and an accountant to do an independent review of the developer's audit. Thirdly, the takeaway of what we've been talking about for the last few minutes is the serious importance of the plans, of having the plans in your possession, ideally the as-bills. One other thing that's very important that we really didn't talk about that happens at turnover, or that begins to happen at turnover, is the potential cancellation of contracts. So you're a new board, you just got elected, and the developer hands you in all of these bankers' boxes of documents, or electronic records these days, a bunch of contracts that are really bad. You don't like the vendor, you don't like the pricing, and you don't like the terms. This is a once in a lifetime opportunity for the board to cancel bad contracts that could not otherwise have been canceled. So if you're locked into a bad contract entered into by the developer board, this is very important, so please listen to this. If you're locked into a bad contract the developer board entered into, you have this golden opportunity once in a lifetime to get out of that, even though you're still in the middle of the term. So that requires the board to call a membership meeting. And generally speaking, you need to have 75% approval of the non-developer. The developer doesn't get to vote on this. 75% of the non-developer owners need to vote in favor of the contract cancellation. But I want to stress it, because a lot of times that golden opportunity, as I call it, is overlooked and boards don't do it. And then, you're stuck with this bad contract. Some of the contracts have to be canceled within 18 months of the turnover, others not. One of the contracts that doesn't require a 75% approval, that requires only a majority vote to cancel, are the telecom contracts, like the bulk communication contracts. Those only require a majority of the owners, but that vote has to be taken at the first owners meeting after turnover. So don't think you can wait 2 years and do that. So there's a lot of contract cancellation opportunities that are really, really important that are triggered by turnover. I don't know if you, yeah, I was going to say,
just a quick comment on that, because yes, those contracts are something we certainly want to pour over, right? Coming out of looking at the audit, we clearly want to understand what the cash position is of this new association that's been formed, and what's going to be the outflow. And contracts are one of the first places to start to see what terms look like, how much cash is going out the door on a monthly basis. But you were talking about some of those contracts, and we always look for those that tend to be the higher cost of the association, and the ones that, quite frankly, historically, they've been the most onerous. You mentioned the bulk cable, where we've seen many times an association's locked in for 15 years.
yeah.
The other one, if you're in a condo setting, is elevators. And elevators tend to be quite expensive, and they also tend to have terms where it's particularly difficult to get out of that. So, in our world, we do turn to someone like yourself and say, Rosa, help us help this association. Because
and the laundry contracts, Will.
I'm sorry?
The laundry contracts too.
Exactly. So those ones there that, tend to, they work out well for whomever is the contract holder on their side providing a certain service, may not be the best case scenario for the association.
100%. That's one really important thing, because remember, the newly elected owner board inherits, for better or worse, the responsibility to do all these things. There's a fiduciary duty that these board members now have to the owners who elected them. They need to be proactive. You know, if you're elected to a newly turned over board, it's really on your shoulders to move the process along and to make sure that no stone is left unturned. And by stones, you know, we're talking about financial issues and construction issues primarily. But, you know, we're also talking about due diligence and doing a good job in accumulating all of these developer records. And do they have to be in, you know, can they be electronic? Yes. But some, I think you might want in paper format, for example, the condo documents that are easy enough to pull online, but, you know, you have to make those available. By the way, all of these official records that you're getting from the developer are going to now become the association official records that any and all owners have access to. So really, as the newly elected board, with management's help, it's your job and your duty to accumulate those records and to have them available for owners who want to review them or even to copy them. But
I'm sorry,
please. No, please go ahead.
So actually, on that point you just mentioned about so Ms. Patrick, by the way, we can see these questions in real time, or we can see them. We can incorporate the answer right then, we'll do it. But like Ms. Patrick asked us, we're getting electronic stuff, not hard copy. So a full size set of construction drawings, I mean, it is a mammoth roll of drawings in a big building. I candidly would prefer the electronic version. In particular, if you get the architects and engineers CAD files, which is a software they use to produce them. But if you got a hard copy set, that's fine. I'd send them to a service straight away and have them scanned, so you have them forever and bookmarked the way that's useful to you. These lists of information that we're saying that you should get. So Mr. Gill asked us about this. These lists are in the statute what has to be turned over. So it's not because we lawyers are so smart. The list is the legislature gave. These are things that they have to do. And then I think this is we're going to get to at the end. What remedies do you have? Like, for instance, I've had a number of developers in the building. Can we still pursue, or which one? We encountered that. It's a very complicated issue. It's very fact sensitive. So this is more reason people hate lawyers. It depends. What theories of law, what warranties are available? The statutes lay out, and the case law lays out. We're not going to make lawyers out of you on this call, but there are implied warranties and statutory warranties that can be pursued. And we also look at your documents because they deal with warranties sometimes too. Ms. Pence asked us that question. So we'll get to that a little bit more when we get to that section. But what I really want to focus on it, just because you terminate a contract with a vendor, you might like the vendor, you just don't like the terms. Okay. So you terminate the contract you don't like, and you want to keep the vendor, then you agree to terms. When we say terminate a contract, we're presuming this contract is terms that are unfair to the association. The price is not market or whatever it is. So you don't need to throw the baby out with the bathwater. You like the vendor, vendor's doing a good job, but you don't like the term, you terminate the contract and say, let's negotiate a new contract with it, which can be done. So it's not an all or nothing. Sometimes vendors give you contracts that are so one-sided, that's not a vendor you want to do business with anyway. But maybe they're doing a good job. Who knows?
That's a really good point, because by terminating the contract really means you're terminating the existing contract with the existing contract terms, and you may want to keep the vendor with better negotiated terms. So that's a really good point, Perry. But one thing that you kind of mentioned in passing were about these developer claims. One of the things that I get a lot, Perry, as a condominium lawyer is how long do we have to file a claim? Let's say it's a condo which just went through turnover, and you have an engineer's report saying there's a lot of bad things, you know, the construction, there are issues and what have you. How long does that newly elected board have to bring a claim against the developer? What's the time frame?
This is another reason people hate lawyers. It sounds like a simple question, but there are some simple answers, but they don't cover all the circumstance. So let me start at the very outside. We have in Florida what we call a statute of repose. And the statute of repose says whatever claim you're going to bring has to be brought within 10 years of certain triggering events that that trigger the statute of repose running. I'm going to call it, this is a gross oversimplification, but completion of the building or issuance of certificate of occupancy. It's more complicated than that, but that's enough for us today. So that's the outside date. You have 4 years to bring a claim, a construction defect claim, from the time that the cause of action accrued. In other words, you became aware of the problem, and this is where it gets a little dicey in the gray area. The law says that for a defect that is not patent, meaning it's not obvious, you have 4 years from the time you knew or should have known of that problem. And so I'll give you an example. There is a body of case law that says when you have a new roof and it leaks right away, you're on notice. Your 4 years is running. Doesn't matter. You know exactly how it's leaking or what the details are. You know. But the law also says that just because a roof is a different case. So let's go to a case that I see some cracking in my garage slab. That could be a problem or it could be perfectly normal, concrete cracks. Let's be clear about that. But there are cracks and there are cracks. And so sometimes what the law says is that it's not what the expert engineer would see looking at that crack. It's what the ordinary person would put them on notice there's a patent defect. So sometimes this gets almost to be a question of fact. The jury or judge decides when you knew or should have known your 4 years started running. So from my perspective, as soon as you sense a problem, you get right on top of it, and if you need to put it in suit, you do. We'll talk about that decision is a different decision to make. But in general, always within 10 years, within 4 years when you knew or should have known for latent defects, or 4 years from when the cause of action accrued, meaning you knew of the problem. And there is we've been in cases where the factual issue of when you knew or should have known and when the statute of limitation started to run goes to the jury and they decide. But that's in broad terms what it is.
So Perry, how come we always hear about that the owners have to rush and make a claim within 1 year after turnover or 3 years after the certificate of occupancy, but no more than 5 years? What does that relate to?
Well,
is that maybe the warranties?
So there's a difference between warranties and when you have a claim on a warranty. So let's just say there are implied warranties in the statute, 3 years for some things, 1 year for other things. But but that's not the same as the statute of limitations. So let's just say you've got a 3-year warranty, and in year 2 that the warranty has been breached. You see the defect. That's okay. So your warranty claim is what we call accrued. You have 4 years to sue for that breach of warranty, unless that would take you outside of the remainder of the statute of repose, if that's shorter. So people think about how long the warranties are, and get confused that with the statute of limitations. No, two different things. One is you have your claim. The other is how long you have to bring your claim in a lawsuit.
Okay. One thing that I think bears mentioning is this claim or this lawsuit that you're talking about. So we have, again, the scenario is we went through turnover. There's a newly elected board made up of owner representatives. We now have an audit telling us how much money the developer owes us. And we now have an engineer's report telling us, how much we have in terms of construction defects. We need to sue because it's now time to make the claim. Who are you making the claim against? Is it just the developer? Are there other potential parties that are responsible? Explain a little bit about who's on the hook.
So I can tell you the way that we look at it. I mean, you could certainly sue just the developer and let them bring third-party claims if they want. I don't care much for that. I like to have control over my own destiny. So we're going to bring suit against, and it really depends upon the nature of the defect. The developer's getting sued no matter what. Almost no matter what, the general contractor is getting sued. Hopefully your engineering report is, you've got the information sufficient enough, this sub is the one who did that work. I'm suing that sub too. Where we sometimes get into a difficult decision is whether we're going to file suit against the design professionals, the architects and engineers, because that a design looks perfect on paper, if it isn't implemented that way in the field, then it doesn't matter, right? It wasn't built the way it was designed. Or a more complicated question is, was the design clear enough? Were the drawings clear enough to tell a contractor what to do in the field? And you may find that you have an architectural claim, not because it was misdesigned in the sense that that won't work, in the sense that it wasn't clear enough. So for us, the people we look at are the developer, the general contractor, the implicated subs, because you have a big project, you got 50 subs, but you only have a scope of work, it's only 2 or 3 subs, and the design professionals. I don't like suing people who don't deserve to get sued because it's another set of problems. But if you're running, your statute of limitations is running, your statute of repose is running, and you've identified a claim and you know it's these people, but it could be other people as well, join them all. And we sort it out. And at least in our firm, I don't mind telling a defendant, listen, here's the reason you're in. Can you give me your information? Let me see if this is really you, or we can let you out of the lawsuit. Because in reality, you want to proceed in litigation only against those folks you have to proceed against, because it's just more efficient.
So Perry, what you're saying now is very important, because a lot of times my clients, my condominium association clients or HOA clients, will have a developer that's gone belly up. They're nowhere around. It's a single, source entity. It's, the ABC Condo LLC, and they're gone. They're gone. So what you're saying is there are other entities that potentially could be on the hook, and
Yes.
hopefully have insurance to back
Yes.
up any claims that you might file.
And something that people don't think about is that it is not uncommon that you find a contractor or a sub who's gone out of business, right? But they have insurance that was on the risk during the period. We don't care if they're out of business anymore. It doesn't matter. We're making a claim against them that their carrier has to come in and defend it if there's coverage has to pay if you prevail. These are the kind of things where a little information can be very dangerous. These can be very complex and complicated issues. But yes, the point for today's discussion is these are the folks who we look at. These are the folks who you can have possible claims against. But suing everybody, that has its charm. But when you make a lawsuit more cumbersome than it has to be, it is not helpful to the association.
So, back in the day when you and I started practicing law, when there was a claim to be filed, you'd run to court and file it. So in a very succinct manner, because it's an enormous body of law, but very succinctly, could you explain what does 558 mean? Because everyone bandies about the term. It's 558 litigation. Very, very briefly, can you advise what that is?
So 558 refers to Chapter 558 of the Florida statutes, which has a mechanism, let's call it just a pre-suit mechanism. The idea behind it was you would put the developer on notice, and the developer would put the downstream people, meaning their contractor and their subs and their materialmen, on notice of here are the problems. And it allowed a framework for people to have some pre-suit discovery and pre-suit analysis of claims and say, if we can resolve things, let's resolve them. So the law is quite clear that you need to give your 558 notices. And the law lays out what the content of them has to be. It has to lay out what the defects are in a way that people can know what you're talking about. And that it gives very defined periods of time for people to respond. I will caution you about this. 558, given a 558 notice doesn't toll the statute of repose, right? So if we're in year 9, and the time's going to run before the notice periods runs, we're going to file suit. And we may ask the court to stay that suit, or the defendants could ask the court to stay the suit until the 558 process has run its course. So that's a trap for the unwary. So the 558 will toll statute of limitations for a period of time, but that doesn't help you any of the 10 years is running out. Any event, the process, listen, sometimes people respond and you can get things resolved. In particular, smaller claims. But more often than not, in my experience, the responses are not serious enough, well thought out enough to avoid you filing suit. But you have to do it. Unless the parties all agree, you don't have to do it. And if you file suit without sending a 558 notice, the penalty is that your case is going to get stayed if some defendant asks for it.
So, all these legal machinations add up. So Will, let me ask you succinctly, because I want to have enough time for final comment. How do you fund this? You're the management agent of the association. They've got to spend all kinds of money on engineers, on accountants, and on lawyers to make these claims. How's that funded?
Yeah, so that is the one of the very first questions, right? This is why when as part of that turnover of documents, we want to look at that audit. We want to gain control of any of the accounts in the name of the association, operating account, if there's been any funding of reserves, see just how much is there. You mentioned before, Rosa, about the capital contributions. What do we have there? And then we have some meetings to understand what do we think we have in terms of how complex this case will be, because we've got to talk with our own engineer, our own CPA, our own attorney about what's an estimate about where we would be here to get a number to begin with here. And so this is where in our particular firm, we have a number of accountants on our own end that can take a good look at where the association is. But at some point in time, we've got to start talking to the bank about how do we fund this thing? Because, I don't know how many of our audience understands the expenses that are about to be incurred. And just starting off with the engineer to do the study, as well as to continue to be a participant when there's action being taken, and someone's going to have to verify that the work has been adequately done and will be approved by the association as acceptable. So once we can arrive at a figure like that, we'll have a discussion with the bank and potentially, looking at a loan for the association, or if they're willing to go back to the membership to raise the funds in the form of a special assessment.
Okay, excellent. So we're running out of time, but I do want to ask my wonderful panelists for final thoughts. What is your final pearls and words of wisdom to our audience before we wrap up? Per, let's hear from you, please.
So let me just pick up. There's two things I want to pick up on that last point about cost. But I got Ms. Cardoso asked us a question about a problem I'm struggling with right now, and you're talking about getting drawings, and she's referring to the developer kept their drawings in Procore software, which is a project management software that's used. And I feel your pain. And electronic documents, whatever it is, we recommend that we engage a vendor who specializes in that, because there are ways to capture databases easier than what Ms. Cardozo is going through. But what I wanted, my closing thing is to get this information, get these drawings, get all this information at turnover, and the cost benefit analysis. The litigation method of resolution of disputes is extremely time consuming and extremely expensive. Sometimes it has to be. Like, so is surgery when you're sick. If you need it, you need it. And I can't emphasize enough how important it is to sit down with the information that's gathered, including the engineer's report on the front end, and say, okay, here's what we think the number is to fix these problems. Here's what we think the number is to litigate the case, and do a cost benefit analysis. You can't predict with certainty what litigation is going to cost, because a lot of it depends on what the other side does. But let's have the discussion. Let's talk about it. Because sometimes, even though the bad guys will get away with it, sometimes it is just more efficient to fix it yourself and move on. Sometimes the problems are so great, it doesn't make sense to do that. So those are my two closing thoughts.
Thank you, Perry. Thank you very much. Will, your pearls of wisdom?
Yeah, I would remind everyone that, the developers frequently have a reputation that they're there to make their money and get out. And I would tell you that there are some good ones out there. The company I worked for, we frequently avoided litigation because we hired the right folks. And I mean, a good general contractor, good subcontractors. So when that first report came back, we handled a number of those things. Perry talked before about it can get really expensive really quick when you have an army of attorneys on all sides who are all drawn into a litigation. So, only take that kind of action against those who are being stubborn and aren't delivering what you were promised when you were on the front end sales side of joining that community. Be careful of when you create your first board too often. We'll have boards being guided by the angriest voice. And so if you go into a 558 situation, your developer turnover, looking for a fight, you're going to find one. Civility still rules the day, and you will get a lot more done if you have cooler heads prevailing and having a good negotiation that's going to leave everyone in a better place at the end of it, because this process is time consuming. It can get expensive very quickly. And I think all parties involved want to avoid that.
Amen to that. And very briefly, to answer one question which has been asked 3 times, if the developer wants to turn over and you can't get a quorum of owners, you can still do it, because the developer appointees will resign. And before resigning, they will appoint the new board members. So the turnover can occur that way. And I've seen it happen many, many times.